So, is Australia completely overhauling the skilled worker visa system starting in 2026? And will thousands of prospective migrants currently in Australia have to change their entire PR strategy or face leaving the country? This is the topic of today's video. In this video, I'm going to go over the major changes just announced by the Australian government that will fundamentally transform how skilled visas work starting July 1st, 2026. I'll be breaking down the new visa tiers, the increased salary requirements, the brand new skills in demand visa, and the major shifts in how permanent residency points will be calculated. In this video, I'm going to go over essentially the legality of these changes, the transition periods for current holders, some massive consequences for those in low priority sectors, and just my general thoughts about it. Overview of the 2026 Migration Reform Package, because I know many of you are concerned about this. We've gotten several messages from people reaching out who are super worried about their path to PR being blocked. So I wanted to address it immediately. First and foremost, welcome back to the channel. I'm a migration specialist who helps foreign nationals navigate the Australian immigration system. As background, I've spent the better part of the last decade analyzing migration trends and policy shifts in the Asia-Pacific region. I've worked with hundreds of applicants on 482, 189, and 190 visas. So I've got quite a bit of experience when it comes to the practical reality of how Canberra's decisions affect your daily life. And hopefully I can, comment on this topic and make it interesting and clear for you. If you like the content, please hit the like button. If you like the channel, please subscribe. That tremendously helps me. And that being said, let's jump right into the topic of discussion, which is the Australian government officially passing the Future Migration Act 2026. What the new rules actually say. And let's jump right into what it actually says. So what this reform package does is it creates a total replacement for the current subclass 482 temporary skill shortage visa. Starting July 2026, the 482 is being retired and replaced by the skills in demand visa. This new visa is divided into three distinct pathways: the specialist skills pathway, the core skills pathway, and the essential skills pathway. It creates a new framework where your eligibility is determined almost entirely by your annual earnings and your specific occupation's core skills status. For the specialist skills pathway, which is for top-tier talent, the government has set a high income threshold. If you earn at least $135,000 per year, you will have access to a fast-tracked processing time of just 7 days and a guaranteed pathway to permanent residency. However, for the core skills pathway, which covers the majority of skilled migrants like chefs, accountants, and software engineers, there is a new requirement. You must earn at least the TSMIT, which stands for the Temporary Skilled Migration Income Threshold, and that is being hiked to $75,000 starting July 2026. If an individual does neither, meaning they don't meet the salary threshold, or their occupation is removed from the newly narrowed core skills list, they will be deemed to have lost their pathway to employer-sponsored PR. So essentially, if your employer cannot match these new salary requirements by the deadline, you could lose your chance at staying in Australia permanently. In addition to that, any migrant who applies for a skilled visa in the future will be subject to a completely revamped points test. The government is moving away from the static points system, where you just count your age and degree. Instead, they are introducing dynamic points that reward you more for working in regional areas or in sectors like renewable energy and healthcare. So given that Australia is a nation built on migration, I understand that so many are concerned about these changes because so many people are currently on bridge visas or temporary work visas hoping for a 186 transition. Consequences for visa holders in low priority sectors. That being said, I want to go over some of the major practical issues and also legal issues with this new system that everyone should keep in mind. Because while it sounds like a cleanup of the system, there's just a lot of important aspects that need to be clarified before July 2026. The first one is the issue of visa hopping, which the government is now banning. So while Australia used to allow people to move from a student visa to a graduate visa, then back to another student visa to stay in the country, the 2026 rules essentially end this. If you are on a graduate subclass 485 visa, you will no longer be allowed to apply for a student visa from within Australia. This creates a massive problem for those who haven't secured a skilled job before their graduate visa expires. You may actually be technically forced to leave the country to apply for any further visas, which this reform package demands to reduce permanent temporariness. In addition to that, the way the points test is changing is by placing a much higher value on the partner's skills. If you are a single applicant, you might find it harder to compete with couples where both individuals are highly skilled. The problem is, the Department of Home Affairs does not have the capacity to process every PR application at once. So essentially, if you are stuck in the core skills tier with a salary just above the minimum, you could be waiting years in a queue, while those in the specialist tier jump to the front. This seems like a rather unfair way of doing that, legally speaking, according to many migration advocates. Challenges with meeting the new TSMIT salary. Similarly, there's an interesting legal issue on the salary side of the bill. It says that if an employer wants to sponsor a worker, they must pay the TSMIT of $75,000. However, currently, many regional businesses and small startups pay between $60,000 and $70,000. While there is a provision that may allow for some regional concessions, it's been essentially very rarely used for standard occupations. And if now thousands of businesses have to suddenly find an extra $10,000 to $15,000 per sponsored employee to keep them in the country, it would create a ton of extra financial pressure for the agency and the businesses involved. New contracts need to be created, and if the employer refuses, the migrant has only 180 days to find a new sponsor, or they must leave. This seems highly unlikely to go smoothly, if you ask me. Financial implications and the cost of PR. Now, on top of all of these legal considerations, there is a massive financial consideration, which wouldn't involve just the visa fees, but more the Skilling Australians Fund, SAF, and the overall cost of the application. If all these visa fees all of a sudden were to increase, which the 2026 budget suggests they will, well, the cost of a family of 4 applying for PR could exceed $15,000 just in government charges. There's a specific set of rules, but if you have a certain number of dependents when you apply, the Australian government treats your application as a high service event and taxes it according to that. So there would be a huge financial barrier. Because essentially the new rules say that anyone who doesn't meet the high salary specialist tier doesn't get priority processing. There could be essentially thousands of families who could be stuck in bridge visa limbo for years, which could become a massive issue as well from a mental health perspective, not just a migration perspective. Practical consequences for current students and graduates. Perhaps the most interesting practical consequence if these changes were to become law is that it would actually negatively impact the international education sector's legacy students. Both the current master's students and the vocational students are under the old promise of a path to PR. So it would require them to radically change their study plans, or move to regional Tasmania or South Australia to get enough points, which is just an interesting sort of practical consequence affecting the education export industry. Constitutional and legal considerations. If all of this isn't enough, there's actually a very big administrative law question, which calls the transition periods into question. There's a concept of procedural fairness, where the department cannot just change the rules for someone who has already lodged an application and spent thousands of dollars. Unless it's a voluntary transition, one usually expects their application to be assessed under the rules present at the time of lodgement. Now, the way this 2026 package tries to go around that is by setting up essentially this sunset clause, where the old 482 rules expire regardless of when you arrived. I am not convinced that that's going to be held as fair for those who arrived in 2024 or 2025 with a clear promise of a 186 pathway. And essentially, these new rules will likely be argued to be a violation of the legitimate expectations of visa holders, as clarified in previous High Court cases. Final thoughts on the changes and your future. If you've gotten this far into the video, you can probably tell that I think that this package is going to be incredibly disruptive. I just think there's too many practical issues and financial issues with this plan for it to result in a smooth transition. So if you're worried about that, I think your concern is justified. But what I do think is the biggest concern is the mere existence of this July 2026 deadline. Because what it shows is that the Australian government is gravely moving toward a guest worker model. What is completely misunderstood here is that one could be a highly skilled contributor without earning $135,000 a year. You could be a social worker, a teacher, or a nurse. People who derive their value from their service, not just their paycheck. And what the problem with these new salary-first tiers is that it could restrict a skilled migrant's ability to essentially live a normal life and take jobs in nonprofits or community sectors. So that's where I would be very, very concerned. Because I'm concerned where this could lead, where this is a first step in sort of a scary pathway towards only allowing the ultra-wealthy or ultra-earners to ever call Australia home. Closing remarks and viewer questions. Anyway, if you found the video helpful, if you have questions about the TSMIT, the Skills in Demand visa, or how many points you'll need after July 2026, post them in the comments section below, and I'll do my best to record similar videos in the future. I know this is a lot of information to digest, but staying ahead of these July 2026 deadlines is the only way to protect your future in Australia. Thank you so much for watching. Bye.